everyone, and welcome to our Beasley Allen webinar series. For those of you who are joining us for the first time, well, we are so delighted to have you. For our returning viewers, we can't thank you enough for your continued support of our program. So today, we're going to explore litigation techniques to protect consumers from damages to two of their most costly assets, their homes and their vehicles. For homeowners, termite infestations can silently wreak havoc on their property, causing extensive and costly damage before they are even detected. And in much the same way, auto defects can silently compromise the safety and reliability of vehicles, leading to potential accidents and serious financial burdens. Now, to cover these topics today, we've got two of Beasley Allen's best consumer fraud lawyers, Lance Gould and Clay Barnett. Together, Lance and Clay, they're going to talk to you about the complex task of investigating and preparing termite and auto defect cases. They'll explain how these cases present a web of contract, warranty, and fraud considerations. They'll discuss the latest litigation trends for termite and auto defect cases. And I think you're going to really enjoy what they have to say to you today. So while we're waiting on the last of our registrants to join us, let's take just a few moments to meet our two speakers. First, my friend and partner Lance Gould is a longtime leader in Beasley Allen's fraud and commercial litigation section. Over the past 25 years at Beasley Allen, Lance has helped thousands of our clients. He's produced numerous multi-million-dollar verdicts and settlements. Lance primarily focuses on whistleblower litigation, attorney general litigation, and consumer class actions. And he frequently serves as a guest lecturer on those topics in programs located throughout the country. So needless to say, Lance is a really huge asset to Beasley Allen, and we are happy to have him with us today. Next, my partner, Clay Barnett, is another principal in Beasley Allen's consumer fraud and commercial litigation section. Clay works out of our Atlanta office. For many years, Clay's pursued pharmaceutical companies for fraud committed against various state governments. Currently, Clay specializes in vehicle and equipment defects class action litigation. Let me say that again. Clay specializes in vehicle and equipment defect class action litigation, where he's successfully represented plaintiffs against some of the country's biggest auto manufacturers. Today, Clay's going to talk with us about his experiences in auto defect cases, and hopefully he'll share some of his recent success stories. Clay is an excellent attorney, and we couldn't ask for a more knowledgeable person to talk with us about this particular topic. So before I turn the program over to our speakers, I do need to go over a few CLE housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. Now, in order for you to get full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you're going to get another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. Just a note, this webinar is being recorded. And for those Alabama and Georgia attorneys who are participating by phone, please email us your name, phone number, and state bar ID number. You can send that to webinars@beasleyallen.com, and that'll help us ensure that you receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout the year, webinars that you'll want to attend and take note of. Finally, if you've got questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, Lance and Clay, let's go ahead and get started.
Thank you, David. Good morning, everybody. I hope you're having a good day so far. We really appreciate you joining us and hope that Clay and I are able to give you some insights on termite and auto defect litigation today. Before I get into my part of the presentation, I want to emphasize the most important thing that you should take away from my presentation today. And that is, as soon as your clients suspect that they have termite damage to their property, the first thing they need to do is critical they contact a attorney that is well versed in termite litigation. That way you can have the attorney come out with a qualified expert to look at the property and determine whether the damage is termite damage related and whether the termite protection services was substandard. A lot of times what property owners do is they will call the termite company and get them to come out and look at the damage or investigate the issue that they have discovered. The problem with that is the reason that the property has termite damage is because that same company failed to provide proper termite protection services. So you're going to ask the company to come out, assess the damage, and tell you that they're responsible because they failed to properly provide the protection that you paid for and they represented that you would receive. The problem that you run into a lot when the termite company comes out is first they may deflect, say it's not termite damage. Next, they may tell you that you have limited damage and may not make the full repairs that you are entitled to. The problem that you have with termite damage is the visible damage is like an iceberg. You just see 10% of the damage that is visible to you without having detailed inspections. Beasley Allen, we have teamed with Termite Tom and the Campbell Law Firm in representing churches, schools, condominium owners associations, assisted living facilities, and other businesses against termite companies who have failed to provide the proper termite protection services that these companies and businesses have paid for. In addition to having qualified lawyers and experts to come out and determine whether the treatment was provided properly, when you're dealing with some of the churches and older historic buildings, we run into a difficult time in finding qualified and knowledgeable experts. The problem that you run into is you have buildings that were constructed in the 1800s. You can't find the craftsmen and the products that you need. We had one expert that he repaired a cathedral, and through his resources and experience, he tracked down the quarry in France where the original tile came from and was able to get that same mine to provide the tile that he needed to make the repairs. So most important thing today from my presentation is once you have suspected termite damage, your client needs to contact a qualified lawyer. Termite damage is a costly problem that homeowners and property owners are confronted with. You have, just in the United States, billions of dollars each year that is suffered in property damage to consumers. The problem is most of the time, if the termite companies adhere to the law and the label instructions on the pesticides, it can be prevented. The problem that we run into is these companies, sometimes they cut corners to save time and save costs, and in doing so fail to provide the protection that the consumers and property owners have paid for and been represented that they are going, the companies represent, we have provided this termite protection service to you. We've followed all the regulations and guidelines, and your home is protected. And each year you get a renewal, and they're supposed to come out and do an annual inspection to notify you of any damages that they have seen. And if there are damages, they have to retreat, or if there are damages, they should repair. And a lot of times the companies do not do that. They just come in and tell you everything looks good and they move on. And when they do that, they don't notify you of the damage or that there's a potential infestation, then the termites continue to eat away at the property. And the damages just get exasperated because they do not take responsibility and do what they should do. there are a couple of types of treatments that they use in order to treat the properties and protect them. One is a chemical treatment. What they do, this creates a barrier around the property with chemicals that keep the termites from entering into the property. What they're supposed to do is dig a trench 6 inches wide, 6 inches deep, all the way around the foundation, fill it with the liquid chemicals, which will soak down into the ground and provide a sufficient barrier to prevent the termites from entering the property. Another thing that's required on the liquid treatments is anywhere there's a crack or a void, such as where a driveway or a carport or porch meets the foundation, they are required to drill holes every 12 to 18 inches and fill those holes with the liquid in order to create a barrier right there. A termite only needs 1/32 of an inch in a crack in concrete to penetrate through the concrete and get into the property, and could be devastating to the property owner's structure. In Alabama, most states have their own statutory similar laws, but in Alabama, you have the Department of Agriculture and Industries. They have the authority to enforce the state laws and the regulations as it relates to the use and methods of treating. One important thing is there's also requirements that these companies maintain records. And the importance about maintaining the records, when you're dealing with some of these properties, especially the historical properties, you will have a termite company or successor termite companies that have been treating this property for decades. And you can go all the way back with those records. You should be able to go back and determine when a treatment was provided, how much, if it was a liquid treatment, the exact number of gallons of the pesticide that was used. And by doing so, you're able to determine whether they follow the label guidelines and or whether they properly treated the property. Most times it's difficult, especially dealing with businesses and churches. In churches, you have turnover and hard to go back and find the person that was dealing with the termite company decades ago. In businesses, the buildings are sold, and a lot of times the paperwork is not maintained. So it's real important that they maintain all of these records as they're required. The first code section that I have here on the slide is for treatment labels. What this is the statute requires that it prohibits the use of pesticides in a manner that's inconsistent with the instructions on the label. The labels provide strict guidelines on how it's to be used and in order to have an effective treatment. On the spot treatment, what that does, it prohibits using spot treatments for the purpose of complete protection for the structure, for complete structural protection. Spot treatments are only intended to protect specific areas. So if they, in violation of this, sometimes you'll see they will not do the full and complete treatment as required. And then in the treatment areas, this goes back to what I mentioned earlier, is that there's regulation that prohibits or that requires treatments of all cracks and void in the soil under dirt-filled structures such as porches, carports, driveways, and things of that nature. And what's important about this is drilling these, it makes them, you can go back and look and see years later whether there was a hole drilled and determine if they did drill the holes every 12 or 18 inches like they were required to do. These are very specific statutes to termite prevention and protection. And a lot of times you see the companies just completely fail to follow the laws and the guidelines on the label. The types of fraud that we deal with, a lot of times everybody, and I'll talk a little bit more about this, but a lot of lawyers will evaluate the case based on a contract claim. That is not the only claims that you have. We'll talk more about the contracts and their attempts to try to limit damages and things of that nature. But the different types of fraud that you have is oftentimes you'll have the technicians, they just fail to thoroughly inspect the property. They'll come out, do their, again, saving time and money, just do a routine walkthrough, look at the property, say everything looks good. Main thing they're interested in is getting you to sign off on that check, on that contract, give them a check and renew each year. So they will represent to you that they've done the inspection. A lot of times they will fail to disclose that there's evidence of termite damage or evidence of a termite infestation. And they would fail to, they're also required to provide notification of any other wood destroying organisms that they find during their inspection. Another type of fraud that we've encountered is treatment fraud. I mean, the company comes out and represents, they follow the law, they follow the guidelines of providing you this treatment and this protection, and they just literally fail to do so. They do not treat it completely like they're supposed to. Another area of fraud that we see a lot is when the property owner does contact the company directly, have some concerns about an infestation or termite damage. The company will come out and again tell you that there's very limited damage, do limited repairs, not repair all of it. They may deflect and say, well, that's water damage. That's not damage from termites, and we're not responsible for that. We've even had instances where the termite company has even tricked an individual into paying for an entire new retreatment when they were entitled to retreatment under contract and full repairs. Again, talk about the importance of contacting a lawyer that is well versed in termite litigation, is because there are a lot of misconceptions, not only by consumers, but by lawyers also. What you see is a lot of people believe that the companies have a lot of methods of deterring lawsuits and avoiding liability that they're responsible for these damages. One of the big things is arbitration. Run into that in the vast majority of these contracts. However, as Tom Campbell, he's one of the ones that started going to arbitration and pursuing these cases. And now there are a lot of lawyers that are able to feel comfortable going to arbitration and being successful in these cases. The next thing that happened is the lawyers and consumers they mistakenly look at their claims based on the express terms of the contract. Again, some of the contracts can be confusing, they can be limited in damages, they limit the dollar amount that they have to pay for repairs. They also do exclude certain types of damages, try to exclude mental anguish, punitive damages, and things of that nature. But fortunately, many times we are able to void those limitations because when the contract is procured by fraud. So we are able to get around that, and you're not just looking at a breach of contract claims. I mean, you have some contracts that say we're not liable for any repairs. It's a retreatment only. If you have an infestation, it's not our responsibility. Due to the fraud of procuring some of these contracts, fraudulently representing, we're providing the services and termite prevention service pursuant to the law and the labels, we're able to get around some of those limitations. Next thing, again, just some more of the tactics that we've seen. I talked about a little bit earlier, is when they come out, the termite company comes out, they'll look at it, and when they do offer to make repairs or retreat, a lot of times both are insufficient and again substandard. The biggest thing is, especially on the repairs, because you can only see 10% of the damage that's usually there. And again, as I said, it's critical you get a well-versed attorney early on in these matters to make sure you are protecting your client's property and one of their most, they're probably their biggest asset in their buildings. Where to look for damage, a couple of areas, places that are good to spot damage is at where the wood contacts the ground around the house, and also in kitchen, laundry room, bathrooms. Those are good areas to look because you have the plumbing drilled through the slab and they're not always treated properly, and the termites are able to get in through those cracks. The attics and the walls and the flooring, that is a good place to look because usually it's not covered by sheetrock. You may have some insulation sitting on in between some of the studs, but generally it is more open as opposed to a bedroom or an office where you have the sheetrock on the walls and you have to do invasive testing or inspections on those. Another thing you can do is check for baseboards and things. If you knock on them and they sound hollow, they just don't sound solid like normal wood. That's one area, one way to try to detect the damage. Just a couple of warning signs to give you an idea of if you do have somebody contact you, whether there are any issues. We've got a few photographs that'll help. What this is this is the visible damage to a support beam. You can see where the mud trails on the wood, and you can see where the wood is actually deteriorating some. Next, what this is you can't really see it as much, but just to show you how devastating they are. This is in the attic, and the building is about 95 feet above the ground, and everywhere you see yellow tape, that is where they're in these beams, and these beams are about 12 by 16 inches. They're huge timbers. But everywhere you see a yellow tape right there, that is just visible damage. And it's amazing how destructive they are, how fast they move. And just know that the inside of these beams, the damage is much worse. And you can't really tell what's going on in there without having a knowledgeable expert to take a look at it. Another evidence to look for are termite wings. That's just an example right there of some that were found in one of our clients' properties. And these are the mud tunnels where they have traveled up the bricks to get into the structure and start eating away at the woods. At the wood, it looks like literally that's what it looks like. Mud has dripped down the walls or on the concrete. And we've even found these inside of homes where they've moved through the outside and created the mud trails inside. What this is hidden damage. This beam right here looks totally fine. I mean, it looks like there are no issues with it. And what you see is a tool that is stuck about 2.5 inches into the wood, not hammered in there, just the force of an individual poking it in. And again, it's the hidden damage that your client needs to be most worried about in these cases. Just real briefly, this termite fraud is not an isolated occurrence. It happens a lot. In 2020, the Alabama Attorney General's office entered into a settlement with Termites for roughly $60 million. The allegations were that the Attorney General's investigation revealed they were collecting the annual premium termite protection renewals, but failed to provide the services that they had agreed to provide and represented they would provide. There was also allegations that anytime a customer suffered damage as a result of the company's failure to provide the termite protection services, that the company routinely charged exorbitantly high annual renewal rate increases in an attempt to force the individuals to cancel the termite bond and not renew it each year. That way they were going to try to avoid making any repairs. As part of the settlement, there were approximately 12,000 customers in Baldwin, Mobile, and Monroe County were to receive retreatments, whether or not their property suffered any termite damage. Next, want to get back to talking about some of the causes of action that we generally bring these cases under is, you know, you do still have a potential for breach of contract, even if it's procured by fraud. Then you just have general negligence and wantonness for not providing the appropriate treatment as they've represented, or as they are supposed to do, pursuant to the label, pursuant to the Alabama regulations and the contract as well. Next, you have causes of action for negligent and fraudulent misrepresentation. As I covered earlier, they represent they provided the treatment. They may represent that they have come in and performed a full inspection as they were supposed to, and they didn't find any problems. And then the representations may be that we're not liable for any of the damage or the repairs, or they represent that they have made all the repairs when they've only repaired a minor amount of the damage. There are some potential RICO violations in those cases also. So one of the big things, especially in the business aspect of it, are damages. And it's a lot of times it's difficult to determine what the damages are. Everybody's a little different. For instance, the condominium owners associations, you have individuals that live there, that is their home. We have some that have a place down at the beach, and all they do is rent it out. Then you have some that rent it out and use it for their personal use. So how do you determine the damages for each individual like that? And then you have a case for all those individuals, and you have a case for the condominium owners association is also is the plaintiff, because they're responsible for certain parts of the structures and the buildings themselves, repairs and all of that. So it can get real complicated, and you get into issues, damages with churches. If what are they going to do in the repairs? Are they going to have to store some of their furniture and things like that? They're going to be able to have services during these repairs? Will they lose tithes? Will they will they lose part of their congregation? And then especially when you get into these historical structures, the cost to repair is substantial. It's devastating. Many of the churches, there's no way they could perform these repairs on their own, but having to pay for them out of their own pocket. Again, you have diminished value of the property. The first one on the cost to repair or rebuild, the big thing there is there are some, like in the FEMA, you have the 50% rule. If the cost to repair the structure is 50%, exceeds 50% of the market value, then you have to rebuild, or if you do repair, you have to bring it up to the current flood management programs. There are also some state or local building codes that have similar issues with that. You have lost profits. We've got one structure we contend we're going to have to completely tear down and rebuild. It's a business, and it's what are you going to do with this assisted living facility? Where are these people going to be during that time? You have all kinds of storage issues, and again, we believe a lot of times you are entitled to punitive damages due to the fraud, pattern and practice of doing this, and just again the gross negligence that is encountered. Next, I'm going to turn it over to Clay. I know that we're monitoring any questions. If we do not have a chance to answer any or all the questions, please email me or contact me directly. But I'm going to now turn it over to my partner and friend, Clay Barnett, to discuss his experience in auto defect litigation.
Yes, sir. Thank you, Lance. Good morning, everybody. Lance covered the home deterioration risk. That is destruction of things that are extremely important to us, whether it be our businesses, homes, churches, etc. This topic will be something that would fall directly underneath those items in terms of importance and impact on us in our daily lives, and that's our vehicles, because we depend on them. That's just the world we live in. A little bit about me. I was a prosecutor of cases involving financial fraud and pricing fraud from pharmaceutical manufacturers, and then got into automotive defect litigation with the Volkswagen diesel case that emerged in 2016. That kind of allowed me an opportunity to get into an area that I had personal experience in just because I was raised around machinery. It's something that interests me. I'm a bit of a handyman, and continue to tweak and work on cars and boats that are my own, and restored some items like that. So this material is it relates to me. And so I'll say that if you do venture into class action work for a product or vehicle, having a personal interest and personal understanding of it and institutional knowledge of it will take you a very long way. Because I like to say this kind of work is a blend of white collar and blue collar, because a lot of us drive these vehicles and having no real idea how they operate. And then some of us have a great understanding of how they operate and can hear a noise and know exactly what it is, or see or feel something in the wheel and know exactly what it is. And then we just kind of, it depends on where we fall on the spectrum in terms of that awareness and understanding of how these things operate, and when they're showing symptoms, what that might be because of. Lance, let's go to the first one, please. So my practice group focuses on product failures that impact occupant safety. Now, a vehicle defect case rarely concerns the entire vehicle. It's a component inside of the vehicle. We tend to prioritize those when it in an order of, say, restraint systems, something that propels the vehicle, with us the engine, the transmission, the drivetrain. Control, then that also incorporates the suspension, the steering systems. And then kind of towards the bottom of the priorities would be the electronic components. That's the navigation systems, the dashboard, things like that, the keyless entry. All of those items are going, if they go bad, can render a vehicle unusable. And so at that point, someone has paid money to purchase or lease, and they're not getting the product that was advertised. Now, these injuries are economic. Certainly, plenty of these defects can result in personal injuries when the vehicles go bad on the road and then cause some kind of collision or a stranding event, which tends to be the most prevalent in our cases, that the vehicle strands the occupants and puts them in harm's way at that point. Next, please. The defect categories on a high level fall into two categories: design and manufacturing. Design is oftentimes disclaimed in the express warranty, which is one of the contract obligations that a manufacturer gets itself into when it puts one of these vehicles out on the road to be purchased. And then the manufacturing defect is one that is covered by the express warranty, but those might be limited to batches. If that makes sense. A design defect is probably going to cover the entire array out of a build range, a model year, or however many years had the offending component. A manufacturing defect may be a subset of a build range, because say they had some sensors that were bad out of from a supplier, and those were limited to a batch. Next. So these are the kind of the bones of Rule 23: numerosity, commonality, typicality, and adequacy. So these are fairly easy to follow in terms of how an automotive class can, with a defective product, can satisfy all four. Numerosity, well, this is a mass-produced item. There'll be thousands of these out there sold. Commonality, if the part is the same amongst the production range, that provides you a common issue of fact, and that is this specific component, let's say, is this master cylinder in the braking system, is it defective? Well, that's a common question. effect. Typicality. Are the vehicles behaving in the same way when they fail? And then adequacy is your class action plaintiff, your filed plaintiff, is he an adequate class rep? Can he put well, one, is his experience typical of the class? And two, can he put the interests of the class above himself? Next, please. Ascertainability is something that lawyers have got to be aware of, and it's fairly simple to satisfy, although it can be muddied by the manufacturers. And so the first question is for ascertainability is, can the vehicles be identified? Well, do they have the offending part? And can that build range be identified? If so, you're on to the next step, which is, well, who owns these things or who leases those vehicles? Well, that data rests with state vehicle registration agencies. That material is available to us, and we use third parties to typically access it. But those two pieces of the puzzle are critical. We'll shift over to damages. Well, damages are like I said, they're economic, but we tend to track two different damage models in these auto classes. One is the cost of repair, and the other is the conjoint analysis. The cost of repair is, well, you have an offending exhaust manifold that's cracking. What is the cost to replace it with a new one? There's your cost of repair. What is the cost to the defendant? Now, that would typically be something that the defendant will put in its own internal conversations and documents. That would be that you would obtain through discovery. You can do a query of repair costs out in the world. That's another way to get to that number. A conjoint analysis is a survey analysis performed by an expert who says to the people out in the public, if you found out that this vehicle had a brake component that failed, how much would you then discount the purchase price? Now, that's an interesting question, because some people may say, well, I wouldn't pay $1 for that car. But when you narrow it down, you can find an average of what consumers may say they would have paid if they'd have known that part had a chance of failing because of a design defect or a manufacturing flaw. Next, please. How do you resolve the class in a way that is going to satisfy the class members? One, you can reimburse them for their out-of-pocket expenses. Say they've already had the part replaced. Well, they've got an invoice to demonstrate that. Extend the warranty. Typically, these vehicles are sold with a 3-year, 36,000-mile limited warranty. The powertrain, which is the engine, transmission, and differential, axles, things like that. Those warranties are longer, could be 5 years, 60,000 miles. However, in our cases, we've found that defendants will run those warranties out to, say, 6 years, 7 years, 8 years, even 10 years, 100 and 150,000 miles. It depends on the part, and that's a function of what that part's expected useful life is. That's a term of the trade there. Windshield wiper obviously has an expected useful life of a few months, depending on usage, but something like a door hinge, well, that's got an expected useful life of 10 years, 150,000 miles at a minimum, assuming that it hasn't been in a harsh environment, or by that I mean extremely harsh environment, like or dunked underwater. So the last piece of the puzzle is that your class will expect is that there's resolution with an improved product. Class members are not going to be all that fired up about just being told that they've got a new version of the same old failing part provided to them. So when you bring all those three together, you can put together a solid remedy that the class will appreciate and clearly accept as a way to move on from the litigation, get it behind it. Next, please. The causes of action. So you'll see we've got 4 here. The breach of express warranty is the one that shows up in the warranty booklet. That's the one that I referred to that typically is the 3 years, 36,000, things like that. I mentioned that a design defect is oftentimes disclaimed. Well, when that is the case, you've got these three below as your fallbacks. And deceptive trade practices counts, implied warranty, and fraud are what we use. Those are our primaries. And they tend to be provable with the same set of facts in discovery. You can bucket those in it like this. Was there a defect? Did the manufacturer know about it? Did they disclose it? Now, how do you, now the question about did they know about it, that is in class actions, that is a, did they know about it at the time of the sale? Sometimes that is a rolling date, as in like the defendant has an idea, but doesn't totally know. But the farther you dig into discovery, the better you can find, you can shape up that they should have known and demonstrate it that they did know. Now, how is it that defendants will know about a product or a part being defective even before they sell a car for the very first one, before a model release? Well, they do pre-release testing. All of these things that we drive out there have been through testing. Otherwise, they would be putting a product on the road and then just hoping that it performs as they intended. No. These guys will tease out a failing part or a fragile part years before they sell it, because they've got to put it through a testing regimen. The warranty data that they receive when one of these comes in, say with 10,000 miles on the odometer, is stored. It creates a transaction because the dealership's got to be reimbursed for the repair. The part is typically taken from the vehicle and then oftentimes is studied by the manufacturer or sent to the supplier to have them figure out what went wrong with it. So that's a source of information that the manufacturers are very much on top of. It is how they control their quality. And so in the discovery process, warranty data is one of the pillars of proof. Next, please. This is a higher level, or more. This is a little more detailed description of what we just discussed. What I'll go to here is the breach of implied warranty. And the test there, is it unfit for its ordinary purpose, or would it pass without objection in the trade? So those are fancy words for, does it do its job? Will it get you around safely? Clearly, that is going to be a front line in the war between plaintiffs and defendant. Well, they'll say, yes, sure, the engine has a terrible miss, and sometimes it won't accelerate from a stop sign into traffic as you expect it to, but that doesn't mean it's unfit for its purpose. So now you get to see where that cause of action really becomes the line of scrimmage, so to speak, in front of a jury. Next, please. How do we vet these things when they come in? Well, certainly it helps, like I said earlier, to have some mechanical knowledge. That way, when you've got a complaint about a vehicle behaving a certain way, because it will come in usually with a layperson description. So we look at, well, does this behavior seem to impact safety? All right, yes, got that. Well, how old is the vehicle? Is this thing a 2002 Toyota Scion? Okay, nope. That thing has gotten it. It's done its job. It's now 22 years old. Yes, things are going to break on it. Oh, well, wait a minute. It looks like this vehicle is a 2023 and it has 15,000 miles on it and it shut off at an intersection. That's the next step. Now you can probably flip 1 and 2 and get you to the same place. And that is it safety? Is it happening early in the vehicle's life? Those are more or less equally important. Now, the uniformity of the defect, that's a fancy way of saying, are the vehicles behaving the same way? Is there a single part or collection of parts failing? And when they do fail, do manifest in a similar fashion. The deceptive advertising marketing, everyone knows that automobile manufacturers are big spenders on electronic and hard copy media. That's how they put their product out there. People listen to it, people see it, people read it. We're influenced by it. And we may think that we're just influenced by the cool looking SUV with the big tires with the Teton Mountains in the background. But that advertising will oftentimes mention that it's got off-roading prowess, or that it's got enough suspension travel to get over, rocks and through mud. Well, that kind of statement indicates that if it can get through rocks and mud, that it ought to do a good job on pavement, because that's a much more tame environment. Well, if that SUV has got a problem with a shock absorber or a shock mount wearing out, that vehicle is not only going to not perform in rocks and mud, it won't actually track straight on a highway. And that's a safety risk, right? Now, the class-wide damages at the bottom, that kind of tracks with is the repair something that will be similar across the affected vehicles? Do the owners and lessees of these vehicles, do they want the same thing? Do they want the value of the repair, reimbursement for out-of-pocket costs, and an extension of the warranty to give them the comfort of knowing that what's been put in there in replacement is actually going to hold up, and then the manufacturers will stand behind it. Next, please. This goes to kind of the bones of a successful auto class, one that kind of gets you from yeah, well, it looks like it's a theory, to absolutely, this is a theory. If it involves engines shutting down because they've got some sort of oil starvation issue, they strand, they even catch fire. All right, obviously, you've got not safe and not reliable. We talked about the pre-sale knowledge and how a defendant or a manufacturer will obtain such material. Next, please. Materiality is an element that the defendants tend to push on in their motions to dismiss. And they say, well, we didn't really have a duty to let the consumers know that this was a problem. Yes, we knew about it, but no, you can't hold us to account for every single little nitpicky thing that goes wrong in our vehicles. If you're wise on the front end and you've prioritized safety, you've prioritized mobility, control, stopping, you're satisfying that materiality aspect. The test is going to be, does it put folks in harm's way? And then there are other, less obvious ways to satisfy materiality. If it's a control system in, say, the dashboard, or the even the heating and cooling. For instance, if the heating and cooling system is failing, and then the vehicle has a high propensity to fog, and then if the driver can't see out of the windshield because there's a heavy mist in there from humidity, and it's cold outside and warm in the interior, that's a material defect, right? Because the person can't see out of the front windshield or other glass. Let's look at the pre-suit notice requirements. These are tied to the consumer protection counts and implied warranty. The letter written to the defendants will say, I represent Mr. Wilson. He has a 2022 SUV that you built. It's behaving in this way. That's not what he expected when he bought it. You're in violation of the following state consumer protection law and implied warranty law. All that to give them the chance to cure. That's called the opportunity to cure. Some states require this, some don't. It is a state-by-state test. It's usually safe to just go ahead and send that letter. The judge at a motion to dismiss may often ask, well, did your client present the vehicle for repair and let the defendant know that this defect or this alleged defect was plaguing the vehicle. Well, yeah, you want to be able to answer yes to that. And let's see, we have some exceptions there. Knowledge is of the defect is, that's one of those things you have to, like I said, there are some ways to essentially imply knowledge. That's through citing pre-sale testing. Next, please. So in 2017, the United States Supreme Court addressed jurisdiction over out-of-state plaintiffs in a mass tort. And then that came in and affected class actions. So there they had a dangerous drug case filed in state court in California. The court said, no, you can't hold Bristol Myers Squibb to face litigation from, say, a Nebraska plaintiff in California. You've got that Nebraska plaintiff just needs to file in Nebraska, or it needs to file where Bristol Myers Squibb is headquartered. Now, that has been expanded. Defendants have tried to expand that to classes. They have had varying success. So the safe approach is to file either where the purchase occurred or where the defendant is got a headquarters, or whether they've got or where they're incorporated. That would be Delaware sometimes. Now, just quickly, the Americans tend to be headquartered in Michigan, Eastern District. Toyota is now in the Eastern District of Texas. California and the Central District has Mazda and Honda. New Jersey has a handful of foreign companies like Germans like Volkswagen, Audi. Nissan is in Tennessee. And here in Atlanta, in the Northern District of Georgia, you've got Porsche and Mercedes. Next, please. This is a question that a lot of people who are investigating one of these things will encounter. Wow. Okay. So the recall has hit. It has captured my truck that was not stopping properly. Is the class action now DOA? Well, that depends. One is, did the recall capture every single vehicle that had the offending part? Two, is the recall actually a cure? Or is it a notice to folks that there's a danger because one of the components is at risk to fail, and therefore then create either a loss of control, loss of braking, fire risk, something like that. So a warning that a part is bad is not necessarily going to foreclose a class, because the purchasers, they bought and expected a functioning brake system. Well, just knowing that their brake system is at risk doesn't make them whole. All right, so what do? We talked about some of the vehicles that have the part may have been excluded from the list of recall vehicles. Another aspect is there an actual cure present in the recall? Is the recall a notice of a problem and then an announcement of a cure? And then finally, for us as the litigators, did the recall happen after we filed? Does it look like we were on the problem a good bit of time before the defendant finally got around and said, man, these lawyers have got us. We need to recall this, because they have, in their complaint and through discovery, figured out exactly what's going on. And so the NHTSA's after us. We better just recall it, own up to it, and then see if we can get a judge to declare the class moot. At that point, plaintiffs' lawyers are going to push for a catalyst fee, and that's a state-by-state analysis there. Next, please. All right, these things are won or lost right here. That's pretty much it. ESI terms, that's where you get your documents. if you know something about the part, you don't need to ask questions like, well, just give us every document that related to one of these things failing stop. No, you can ask questions like, we want to know what problem solving root cause analysis group went after the hydraulic system because they had reports of it suffering air ingestion, or they know, or perhaps there was a hydraulic seal failure in that, and we want to know everything related to what you guys found related to that seal inside of that hydraulic pump. So the more you know about the material, the tighter your discovery requests are going to be, and certainly the tighter your electronic search terms are going to be. Design schematics, those are usually for your experts to be able to put a report together to say, this is what the part is, these are the components to it, this is what's going wrong. I need to wrap up so I can get to this GM trial, but I mentioned to you consumer complaint data. That's very similar to warranty data. Those are where folks are saying, look, this vehicle came to a stop at a stoplight and didn't restart. Well, those are all cataloged by the defendants. Next, please. 30B6 depositions. Defendants love to use these to present a guy who's going to tell you things that you don't want to hear. Depose the engineers, the ones who are out there designing and testing the parts. Former employees, obviously, those are great for admitting things because they don't have concerns about their job being in jeopardy. Now to trial. So we took next, please, Lance. Let's go on to yeah, this one's good. This one's good. We took GM to trial in California in September of 2022. It concerned a V8 that they put in pretty much everything that you recognize GM for, which is their SUVs and pickup trucks. They warranted those engines for 5 years, 100,000 miles. Well, these things started burning oil and tearing up their piston rings at like 20,000 miles. And GM put that into documents because they saw it through vehicles coming in. And we won this thing at the deposition phase because we got the documents that had them discussing it internally. We deposed the engineers who were on fact-finding missions to figure out what was going on and how to get ahead of it. We found them coming up with alternative improved parts. We found them kind of, in a way, arguing about how much weight they ought to put on this defect. And that was entertaining, and got that out of them in deposition. So they came to trial with the idea of, we have a lot of admissions on paper and these depositions on video, and they're not fixed. So they brought witnesses to try to undo what was said in deposition. The jury obviously was not all that persuaded by the explanations for, well, that's really not what I meant when I said that, and to you 4 different times because you asked me 4 different ways. So what we asked for was the price of a new set of pistons, or really the cost to GM for a new set of pistons in those engines. That number was in GM's documents that they produced that we asked for, and the jury gave it to us for the 3 states that we had before them, which were California, Idaho, and North Carolina. And I'll hand it back to David.
All right, thanks so much. On behalf of all our viewers, I want to thank Lance and Clay for a wonderful presentation. You guys do amazing work, and I really enjoyed learning from you. I know our audience does as well. Hey, for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys who participated today by phone, please email us your name, your phone number, and your state bar ID number. send that to webinars@beasleyallen.com because that's going to help us ensure you get full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding exciting webinars throughout the year. Thanks again for joining us today, and thank you for supporting our Beasley Allen webinar series. Have a good day.